In this lecture, we will discuss about the formation of National Medical Commission Act 2019. So, while discussing about introduction, we will deal in particularly the very background of the Indian Medical Council Act 1956 and its very performance and what was the very need of repealing the act and forming National Medical Commission Act as the very background of forming National Medical Commission Act 2019. We discuss about the Yashpal Committee, the National Knowledge Commission, and the Parliamentary Standing Committee and Professor Ranjit Chowdhury Committee report and the views of NITI Aayog. So, in particular, the Medical Council of India is established under the Indian Medical Council Act 1956 in order to maintain standards of medical education, give approval to establish medical colleges, medical courses, and recognize medical qualifications. The Medical Council of India is also responsible for the regulation of medical practice, including registering doctors in an All India Medical Register. States have their own laws that establish a state medical council to regulate matters related to ethical and professional misconduct of medical practitioners. Over the years, there have been several issues with the functioning of the Medical Council of India with respect to its regulatory role, composition, allegations of corruption, and lack of accountability. So, in 2009, the Yashpal Committee and the National Knowledge Commission recommended separating the regulation of medical education and medical practice. The recommendation stated that the MIC should should not be responsible for regulating medical education and should be a professional body that conducts qualifying examinations for entering the medical profession. The Parliamentary Standing Committee in 2016 and the Expert Committee under the chairmanship of Professor Ranjit Chowdhury and the NITI Aayog in 2016 have suggested legislative changes in order to overhaul the functioning of the Medical Council of India. The NITI Aayog recommended changes in the composition of the Medical Council of India and creation of several autonomous boards in order to address different functions such as medical education and qualifying examinations, medical ethics and practice, and accreditation of medical colleges. The National Medical Commission Bill in 2017 was introduced in Lok Sabha. It was examined by the Standing Committee on Health and Family Welfare, which submitted its report on March 20, 2018. The committee gave several recommendations with regard to composition of the National Medical Commission, fee regulation for at least 50% of seats in private medical colleges, and the licensed examination be integrated with final year MBBS examination. However, the 2017 bill lapsed with the dissolution of the Lok Sabha. The National Medical Commission bill was introduced in 2019 and it repeals the Indian Medical Council Act 1956, which became an act, and the very salient features of the National Medical Commission that we will discuss is regarding the very composition and function of the National Medical Commissions and those autonomous boards, then Medical Advisory Council, then qualifying examinations and community health providers, professional and ethical misconduct, then those offenses and penalties as provided under the National Medical Commission Act 2019. So the Act set out the National Medical Commission, which will consist of 25 members. A such committee will recommend names for the post of chairperson and part-time members. The term of the members of the National Medical Commission will be a maximum of 4 years with no reappointment. The such committee will consist of 7 members, including the Cabinet Secretary, Union Health Secretary, and 5 experts nominated by the central government, of which 3 have experience in the field of medical education and medical profession. Members of the National Medical Commission include the chairperson, 4 presidents of the board set up under the National Medical Commission, the Director Generals of the Directorate General of Health Services and the Indian Council of Medical Research, Director of any of the AIMS, All India Institute of Medical Sciences, 2 persons from amongst the directors of medical institutions such as Jimpar, Puducherry, and Tata Medical Hospital, Mumbai, 5 members part-time to be elected by the registered medical practitioners and 6 members appointed on rotational basis from amongst the nominees of the states in Medical Advisory Council. The very functions of the National Medical Commission include framing policies for regulating medical institutions and medical professionals, assessing the requirements of healthcare related human resources and infrastructure, maintaining guidelines for determination of fees for up to 50% of the seats in private medical institutions, and deemed universities which are regulated as per the National Medical Commission Act 2019. Medical qualifications granted by any statutory other body in India which are covered by the categories listed in the Act. Under the Schedule B, we recognize medical qualifications, institutes of national importance such as All India Institute of Medical Sciences and Jimpar have their own Act of Parliament, and they do not fall under the National Medical Commission. So, the autonomous boards constituted under the National Medical Commission Act 2019 are 4 in number for the supervision by the National Medical Commission. Each autonomous board will consist of a president and 4 members, of which 2 will be part-time members appointed by the central government. So these 4 autonomous boards under the National Medical Commissions are undergraduate medical education board formulate standards for undergraduate education course examination norms for faculty, infrastructure in medical colleges and recognizes medical qualifications. And the second board consists the postgraduate medical education board, which formulates standards for postgraduate and super specialty education courses, examination, norms for faculty, infrastructure in medical colleges, and recognizes medical qualifications. While the third autonomous board is the medical assessment and rating board, which grants permission to establish medical colleges, start new postgraduate courses, or increase seats, assesses and rates medical colleges, and levies penalties on colleges that fail to maintain minimum standards. And the fourth important autonomous board is the Ethics and Medical Registration Board, which regulates professional and ethical conduct and maintains a national register for all licensed medical practitioners. It also maintains a national register of community health providers. And regarding Medical Advisory Council, the central government will constitute a Medical Advisory Council. The council will be the primary platform through which the states and union territories can put forth their views and concerns before the National Medical Commission. Further, the Council will advise the National Medical Council on measures to enable equitable access to medical education. As relating to qualifying examinations, there will be a uniform national eligibility entrance test for admission to undergraduate and postgraduate medical education in all medical institutions regulated by the Act. The National Medical Commission will specify the manner of conducting common counseling for admission in all such medical institutions. The Act also provides a common final year undergraduate examination called the National Exit Test for the students graduating from medical institutions to obtain the license for practice. The National Exit Test will also serve as the basis for admission into postgraduate courses at medical institutions. Foreign medical practitioners may be permitted temporary registration in India in such manner as may be provided or prescribed. Regarding community health providers, the Act states that the National Medical Commission may grant limited license to certain mid-level practitioners connected with the modern medical profession to practice medicine. These mid-level medical practitioners may prescribe specified medicines in primary and preventive health care. However, in other cases, these practitioners may only prescribe medicines under the supervision of a registered medical practitioner. And regarding the appeal on matters related to professional and ethical misconduct, the state medical councils will receive complaints relating to professional or ethical misconduct against a registered medical practitioners. If the medical practitioner is aggrieved of a decision of the state medical council, he may appeal to the Ethics and Medical Registration Board of India. The State Medical Council and the Ethics and Medical registration board have the power to take disciplinary action against the medical practitioner, including imposing a monetary penalty if the medical practitioner is aggrieved of the decision of the board. He can approach the National Medical Commission to appeal against the decision. And as regarding the very offences and penalties, the National Medical Commission Act of 2009 provides no person is allowed to practice medicine as a qualified medical practitioner other than those enrolled in a state register or the national register. Any person who contravenes this provision will be punishable with imprisonment of up to 1 year or a fine extending to 5 lakh rupees or both. So, in detail, we would like to discuss the very composition and function. So, as per the Act, it said the Medical Commission as the regulator for medical education and practice. The National Medical Commission would consist of 25 members, of which at least 15 are medical practitioners. The current regulator is the Medical Council of India, which is an elected body where the president members of the Medical Council of India are elected by the medical practitioners themselves. The Act replaces the Medical Council of India with the National Medical Commission, which is not an elected body. The Parliamentary Standing Committee, when examining the very composition of the Medical Council of India, noted that it is not diverse and consists mostly of doctors who look out for their own interest over public interest. The committee recommended that to reduce the monopoly of doctors, the Medical Council of India should include diverse stakeholders such as public health experts, social scientists, health economists, and health-related non-governmental organizations. So, also, it led to another important power, that is power to set the fees. The National Medical Commission power to frame guidelines for determination of fees for up to 50% of seats in private medical colleges and deemed universities. The question is whether the National Medical Commission as a regulator should regulate fees charged by private medical colleges. Typically, the private sector is driven by a profit motive, but in India, the Supreme Court has held that private providers of education have to operate as charitable and not for-profit institutions. In 2002, the Supreme Court ruled that the fees charged by private unaided educational institutions could be regulated, also while banning capitation fee. It allowed institutes to charge a reasonable surplus which has to be used for its expansion and development. However, several experts committees have noted that many private education institutions charge capitation fees, which makes medical education unaffordable and inaccessible to meritorious students. Therefore, currently the private unaided medical colleges, the free structure, is decided by a committee set up by the state governments under the chairmanship of a retired High Court judge. This committee decides whether the fee proposed by a college is justified and its decision is binding. On the other hand, private colleges claim that fees need to be revised periodically to cover for increasing cost of maintenance, administrative expenses, revision in pay to faculty and staff, maintenance of laboratory equipment, additional resources required for value added courses and other unforeseen circumstances. The NITI Aayog Committee in 2016 was of the opinion that a fee cap would discourage the entry of private colleges, therefore limiting the expansion of medical education in the country. It also observed that it is difficult to enforce a fee cap and could lead medical colleges to continue charging under the table capitation fees and other periodic fees on various contexts. So now we would like to discuss regarding another important provision under the National Medical Commission Act, and that is the appeal on decisions related to professional and ethical misconduct. As under the Act, the State Medical Council established under respective state laws will receive complaints relating to professional or ethical misconduct against a registered medical practitioner. If the medical practitioner is aggrieved of a decision of the State Medical Council, he may appeal to the Ethics and Medical Registration Board. The State Medical Council and the Ethics and Medical Registration Board have the power to take disciplinary action against the medical professional, including imposing a monetary penalty. If the medical practitioner is aggrieved of the decision of the board, he can approach the National Medical Commission to appeal against the decision. It is unclear why the National Medical Commission is an appellate authority with regard to matters related to professional or ethical misconduct of medical practitioners. It may be argued that issues related to ethics and misconduct in medical practice may require judicial expertise. For example, in the United Kingdom, the regulator of medical education and practice, the General Medical Council, receives complaints with regard to ethical misconduct and is required to do an initial documentary investigation in the matter and then forwards the complaint to a tribunal. And that tribunal is a judicial body independent of the General Medical Council of United Kingdom. The adjudication decisions and final disciplinary action is decided by the tribunal. Further, the Act does not specify a time period for the National Medical Commission to decide on such an appeal. Note that the Parliamentary Standing Committee in 2018 stated that giving the appellate jurisdiction to the central government does not fit into the constitutional provisions for separation of powers. So, it recommended constitution of a medical appellate tribunal instead. And as regarding now, we would like to discuss the very composition of state medical councils. So, where there is a state law which confers power on the state medical council to take disciplinary action against professional and ethical misconduct, by a medical practitioner, the State Medical Council will redress complaints related to misconduct by medical practitioners. So, at present, almost 29 states have established state medical councils which are required to prescribe a code of ethics for regulating the professional conduct of medical practitioners and take disciplinary action against them for violating the code of ethics. In various states including Gujarat, Maharashtra, and Delhi, the State Medical Council is an elected body composed primarily of medical practitioners governed by their own respective state acts. In this context, the NITI Aayog on draft National Medical Commission Bill in 2016 has noted that there may be a conflict of interest if members of the regulator, the state medical councils primarily consist of medical practitioners are elected by those that are regulated by it itself by the medical practitioners. The Parliamentary Standing Committee also in 2016 noted that the Ethics Committee of the current Medical Council of India consists entirely of medical doctors and is thus a self-regulatory body which will have a tendency to protect its own flock. It further observed that the State Medical Council delay ethics related adjudication beyond 6 months, the stipulated time limit to give a decision and no action gets taken against errant doctors. The committee recommended inclusion of laypersons in the State Medical Council to ensure more accountability on issues of medical ethics. And now we would like to discuss regarding renewal of license to practice by a medical practitioner. So the Act introduced a national exit test for students graduating from medical institutions to obtain the license to practice as a medical professional. As the Act does not specify the validity period of this license to practice, in other countries such as the United Kingdom and Australia, such a license to practice need to be periodically renewed. For example, in United Kingdom, the license has to be renewed every 5 years. And as in case of Australia, it has to be renewed annually. This is to ensure that doctors are up to date, fit to practice, and able to provide a good level of care. For this purpose, they must show continuing professional development and unobjectionable criminal record and adherence to professional standards. So, this is all about the National Medical Commission Act 2019, which we have discussed the very background of the enactment of the National Medical Commission Act to replace and repeal Indian Medical Council Act and to replace the Medical Council of India. Very salient features that regarding the composition and function, the autonomous boards and medical advisory council, the qualifying examinations and community health providers, and the most important aspect that relates to professional and ethical misconduct and the other aspect relating to the offence and penalties and the very role of state medical councils and renewal of license to medical practitioners that we have discussed. So we have completed our valuable discussion relating to National Medical Commission Act 2000.